Come to order.
All right, before we begin, I will ask the media, we have more media here than we have room, so I'm going to ask that they share with those who are not able to make it in here today, please. Thank you.
Calling the matter of People versus Wesley Brownlee.
Mr. Brownlee, this is the date and time for your arraignment. An arraignment is the first stage of a criminal case where you're informed of what your statutory and constitutional rights are. Those rights are as follows. You have the right to know the charges filed against you and to know the minimum and maximum punishments for those charges. You have the right to an attorney at all critical stages of your case, including this stage. If you would like to hire your own attorney, you do have the right to have a reasonable continuance so you can do so. If you cannot afford an attorney, you do have the right to have an attorney appointed to represent you at little or no cost to you. You have the right to a speedy and public preliminary hearing to ensure that there is at least probable cause to believe you committed the offense before you can even get to a trial. You have the right to a speedy and public trial before a judge or a jury, and you cannot be convicted unless there is proof beyond a reasonable doubt that you're guilty of the charges. At those hearings, you have the right to confront and cross-examine all of the witnesses that may be called to testify against you. Also at those hearings, you have the right to present a defense, which includes the right to testify, the right to put on witnesses on your own behalf, and to produce evidence, and to have free subpoenas to get your witnesses and evidence to court. Finally, you have the right against self-incrimination. This means no one can force you to testify or admit the violation, and your silence cannot be used against you in any way. I do need to disclose that my son-in-law is a deputy district attorney in this county. He will not appear on your case. He does not appear in front of me. It will not affect my ability to be fair, but it is my duty to disclose that. You are charged by way of an amended complaint in count one with a violation of Penal Code Section 187, murder of one Jonathan Rodriguez Hernandez. You are charged in count two with a violation of Penal Code Section 187, murder of one Juan Carlos Carranza-Cruz. You are charged in count three with a violation of 187, murder of one Lawrence Lopez. As to each of these charges, you're also charged with intentional discharge of a firearm causing great bodily injury or death. Also charged with use of a firearm in commission of a felony. Also charged with a special circumstance of multiple murders. The minimum punishments for these charges would be life in prison without the possibility of parole. The maximum punishment would be death. Did you understand the rights I just went over with you?
Yes.
What would you like to do with your case today? Would you like me to appoint an attorney to represent you?
Yes.
And can you afford your own attorney?
I'm not sure at the moment.
Then I'm going to go ahead and appoint the public defender to represent you. We're going to pass this for just a moment. Who has this for the people? Mr. Grau, there's a trailing traffic infraction for unlawful to disobey signs or signals from December of 2020.
Today we're not dismissing it, Your Honor.
You will not be dismissing it?
Correct.
All right, that'll trail.
Thank you, Your Honor. Allison Novera on behalf of the Public Defender's Office, and will be accepting this case today. I have reviewed the complaint. We would waive formal reading of arraignment and rights. At this time, I believe we are requesting to come back for further arraignment on November 14th.
At this time, the case will be assigned to Judge Villaculua for all purposes. What day did you want?
November 14th, Your Honor.
November 14th. That'll be at 8:30 in Department 9A, I believe.
Judge, for purposes of the record, I do want to state something about bail.
Yes.
Pursuant to Article 1 of Section 28, the court must take into consideration the protection of the public. Additionally, under Article 1, Section 12 of the bill, it's prohibited for capital cases. Here, the defendant is charged with 3 murders with the multiple murder enhancement, making it a capital case. Between August 20th, 2022 through September 27th, 2022, the defendant shot and killed 3 victims listed in the complaint. On October 15th, 2022, the defendant was apprehended by the Stockton Police Department and was found to have a firearm. That firearm is commonly known as a ghost gun in his waistband. Those facts are reflected in the count 4. The firearms listed in count 4 and the ballistic evidence discovered at the scene of the 3 murders have been examined, there is high confidence the firearm is linked to those 3 murders in the scene. In addition, cellular data associated with Mr. Brownlee places him at the locations in the temporal proximity of the multiple murders that we have charged in the complaint. At least 3 other murders are being investigated, or actively being investigated by the DA's office. In those cases, it is indicated that Mr. Brownlee is associated with those cases. They are 3 uncharged murder cases. Lastly, as publicly mentioned by the Stockton Police Chief, prior to being apprehended in the early mornings of October 15th, Mr. Brownlee was seen stalking various unsuspecting victims at the local city park. At that point, the Stockton Police Department decided to apprehend him. When he was apprehended, he was found with a firearm, and because of these facts, we're asking the court to find no bail. In particular, by clear and convincing evidence, there is no alternative method for incarceration.
Any comments, counsel?
Submitted.
All right. Under Article 1, Section 28F3, I do find there's a public safety risk. For that alone, he would be held without bail. Also, Article 1, Section 12A, he's not entitled to bail. So for those, both of those reasons, the court will be setting bail at no bail. I have considered alternative methods such as GPS and court orders. Given the nature of the charges, I think there's little belief